Good evening, everyone, and welcome to the May 21st special meeting of the Rochester Planning Commission. And we'd ask the clerk to call the roll.
Yes, Chairman McGee.
Here.
Vice Chairman Lord. Excused. Mayor Bixon.
Here.
Mayor Pro Tem and Secretary Bavacqua. Excused. Commissioner Clark Martin.
Here.
Commissioner Gosson.
He's here.
Commissioner
Gotta come off
Potruskoff is excused. Commissioner
Here.
Stone.
No.
Sorry, that was Gasson that said here.
Ooh,
Here's Mr. Lord coming in.
okay, but not Mr. Stone.
Mr. Gasson, I see, is here now.
Yeah.
Yeah, he was here. He just was on mute, I think.
Dean is not here.
Yeah, that's surprising.
Haven't heard from him yet.
Okay,
Yeah, I'll text him while we're.
So do we have, hi, Eric.
we have a quorum.
That makes 5, right?
You're, yeah, 1, 2. Yep,
Okay, we have
Yep.
a quorum.
yep.
I suspect others will come in a little bit later, and maybe the weather has something to do with it being nice. Please join me as we recite the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. Just a reminder to the public who are listening, this is a virtual City Planning Commission meeting. And by virtual, I mean that it's all being done online. You can see that, of course. This is made possible by an executive order by the governor in response to the COVID crisis. And just a reminder that any action taken by the Planning Commission at this meeting actually counts. It would be a legal motion carried. So just with that reminder, I'd also point out you should be seeing a call-in number at the bottom of your screen if you're watching on community television. And if you have questions as we go through the agenda tonight, feel free to call that number, and we'll do what we have to do technically to make you part of the meeting. At this point, I will open it for public comment and ask Siona or James if you have any calls or any communication from the public at this point.
Not at this time.
Okay, thank you. The next item on the agenda is a review of the minutes of the Planning Commission meeting of May 4th. Ask if the commissioners have all had an opportunity to review the minutes. And if you have any, Mr. Stone, good evening.
Good evening, Dennis.
If you have any additions, deletions, or comments about the minutes from May 4th.
I so moved.
So it's been moved by the mayor to approve. Is there support?
Support.
And the roll call, please.
Bixon,
Yes.
Stone,
Yes.
Clark Martin,
Yes.
Gosson,
Yes.
David, we know you're there.
Yes.
Lord,
Yes.
McGee.
Yes.
I believe that's it. Thank you.
Okay, thank you. The principal reason for our meeting tonight is for a risk management refresher, kind of a course, similar to what we did the last meeting, which I have to compliment the staff again for putting that prep on the master plan together. I thought it was very valuable. But tonight, risk management refresher, and this will be given by our planner, Vidya.
Thank you, Mr. Chairman. Many of the Planning Commission members have served for a long time on this board. Some of you are new, and I know everyone has had some form of training or the other, but it's always important to have a little bit of a refresher and a reminder of what so-called rules of the game are in planning. So that said, I would like to take a brief moment to do a short presentation on risk management and conflict of interest. So next slide, please, Siona. So it's not possible to avoid litigation always, because we do live in a litigious society. So there'll always be somebody who will threaten a lawsuit. But what we can do is manage our risk and liability. And that can be done by avoiding conflicts of interest, using consistent rules and procedures, treating everyone fairly and consistently, have decisions based on standards and fact, and very, very important, to maintain accurate and complete records. In this day and age of Freedom of Information Act and people being able to ask for public information, it's very important that we keep meticulous records on our actions, what was done and why it was done. Next slide, please, Siona. The first item we will discuss is conflicts of interest. Next slide, please. So conflict of interest comes under several categories. A member must abstain from discussion and voting when you have some financial tie to the project or the applicant. Either you're employed by the applicant or the firm that is applying. You either own or lease property that is involved or will have its value affected. In some way, shape, or form, if you're financially impacted by the project or the applicant, you must abstain from discussion. If the person who's presenting happens to be a relative or a close friend, that's also a good reason to stay away from the project. And finally, city officials cannot represent applicants. I know it seems pretty basic, understood, but you would be surprised at how many times meetings have taken place where people just represent a friend while also being an official, which is not a good idea. A conflict of interest should always be declared at the beginning of the meeting or the item itself. And then the chair, if it's any one of these categories, the chair will accept the member abstaining. In Rochester, typically the member just sits back quiet and does not participate in a discussion. But the ideal thing to do is for the member to actually get up off the podium where you're sitting and go and sit among the audience. You should not give any impression that you are actually part of the discussion. So, but while what we do is okay, the best way to do it is if there is a conflict of interest and it's accepted by the body, you just get up and leave the dais. You can come back once the voting is over on that matter. So you clearly distance yourself from the project at hand.
That brings up a question, Vidya. Does the commission have to approve they have to accept the conflict of interest by a motion to exempt the member from voting?
Yes, it is in many communities, they do that as a part of rules or procedures. I have not seen anything set in stone. Sometimes an applicant, sometimes a board member declares that they have a conflict and they excuse themselves and the chair just accepts it. But I think the right way would be for the chair to accept it and for the board to vote unanimously. You don't need to take a roll call vote, but you can take a unanimous vote on it to excuse the member from participating in the case.
Stuart, any comment on that? I don't know how the council handles that.
Yeah, I mean, we've had people just say they're not going to vote and then sit there. But I think we did vote to allow them not to vote, because I think we're supposed to vote. So then we voted to that they could not vote.
So it should almost be maybe in the policy that if that is the case, that the member would get up and leave the table until the discussion's over.
The challenge for the member still sitting on the table happens if it happens to be a close vote. Say you're split 3-3.
Yeah.
And the abstaining member, now the pressure is on them because they are sitting at the board, and then the discussion comes into maybe they can participate to render a decision one way or the other. To avoid creating that uncomfortable situation and possible conflict of interest, the member should actually leave and sit among the audience or something. So you don't have a question where you have a split vote, you decide maybe we should allow this member to participate. So I think it's a good idea to take a vote and excuse that member formally from participating in that particular agenda item.
Okay.
Mr. Chairman, this is Gasson. I have a question of the planner.
Yes.
Item 2, relative or close friend.
Mm-hmm.
It's easy to determine relative. It's probably a gray area to determine close friend. Is that branch into work associates and that sort of thing? Or how do you determine close friend?
A close friend, when the member who has got this conflict of interest declares it, they would specify what kind of close friend. Is this your next door neighbor with whom, you have weekend parties, or somebody with whom you are in close contact all the time? In that case, the board might think, yes, you rendering a decision on a project that's going to affect immediately whom you interact with on a regular basis is not okay. On other hand, if you're saying this person is a friend with whom I go to a gym together, the chairman can determine that is not really a conflict of interest. After all, you can't avoid people within the same community all the time. And at that point, the chairman can say, okay, that is not considered a conflict of interest, and the board can vote too.
Thank you. I get that now. I appreciate it.
Yeah, Chairman, but I think if you ask the attorney what's a conflict of interest legally, it's a lot more narrow than what we might all think it is. So it's a tough call sometimes.
Right. I think when in doubt, having an attorney also chime in is a good idea, because after all, that is the way you can assess the risk for a possibly litigious project, especially if the project is contentious,
But I bet you the lawyer would say a close friend is okay, where we might not think it is.
Yes, I think to err on the side of caution is a better idea.
Thank you.
Okay.
So next slide, please, Siona. So now here we have several situations which may constitute a conflict of interest. You are the applicant is a relative, the applicant is a neighbor, your firm works for the applicant, or the applicant is a business associate, business competitor, or you do not want to vote contrary to overwhelming public comment. Which ones would you say is actually a conflict of interest in these? Which ones? Just a mini quiz.
Applicant's a relative.
Correct. B would be a conflict of interest.
The neighbor we just talked about, D, I don't know. I mean, maybe the guy works for GM and so do you, but there's 200,000 people who work for GM.
I would say applicant is a neighbor is not necessarily a conflict of interest unless I described the situation previously. So your firm works for the applicant is definite conflict of interest because there is financial gain or loss to your firm based on the decision. Your applicant is a business associate or a business competitor. Both of those are also possible points and conflicts of interest, because there is a chance you might be taking a decision to take a business competitor out of the equation for a project in the future. It might not be this particular project, or it might be a business rivalry that is trying to be settled through this project where you're in a position of power and that person isn't. So if the applicant is a relative, either your firm or you directly work for the applicant, or they're a business associate or a business competitor, are clear points of conflict. The fact they are a neighbor is up for debate because it depends on just how neighborly you are. Sometimes we know neighbors, it might not work. So that is an issue, like Mr. Gasson said, we would bring it up and you would declare what the perceived conflict of interest might be, and the board can determine that it is or isn't.
Kind of have to pass the smell test, huh?
Yes. Next slide, please, Siona. Yeah, good decision making. Now, this is very, very important. Firstly, if you have a plan, you need to stick to it. And while we like things moving fast, and so does an applicant, because time is money for them, you need to have a long-range perspective. The decisions you take today will have an impact in the future. So sometimes a commissioner might serve on the board for 2 years and might have come onto the body hoping to make a difference in that short time span. They might not see a tangible change in their time span, but whatever decision they are taking will have an impact for the future. So do have a long-term vision in mind. That is important. And also sometimes you will get a project coming along that will be a perfect example of implementing a master plan, or say a mobility plan that you have. Grab that opportunity, because not every community is lucky or fortunate enough to get these opportunities coming towards them. And so when you have the chance, if feasible, you should go for it. Next slide, please, Siona. Now, good decision making does start with knowledge. Cliched as it may sound, knowledge is power. You need to educate yourself on the details of the project itself. And any decision you make should be made based on the standards of the ordinance, not just on public opinion. I think the Rochester Planning Commission has seen several projects where you have had the room packed with residents and neighbors opposing a project. Their input is very important because they are the people who are going to be affected. But a project doesn't have to win a popularity contest, because your job is to look at the long-term vision. What was planned for that area? What are the impacts going to be? And does the project meet the standards of the ordinance? If all those boxes are checked and still you have an entire room full of people saying, we just don't like the idea of it being there, that should not be your reason for denial. So you should deny or approve whether the application meets or does not meet the ordinance. It should be clear cut, as far as possible. It shouldn't be abstract and it shouldn't be as simple as saying, I just don't like the idea of this. Next slide, please, Siona. I'll go into that in a little bit more detail. Whenever you get an agenda before the meeting, please take the time to just go through the application, site plan, and supporting materials, and the planner's report. The planner typically makes a recommendation to you, and those recommendations are based what is currently in your ordinance, what does your master plan say, and it always keeps in mind what the state law is. Sometimes you might not agree with the planner's recommendation, and that is perfectly fine too. But if you do so, make sure that you question what is the standard for it. If you disagree, those also need to be made based on standards. If you have questions, never hesitate to ask those questions and ask for more information. So don't feel pressured into making a decision because, hey, an applicant is appearing for the second or third time before the body. We have to give a decision. If you're still unsure about something, ask for additional information. Don't just postpone them without giving them guidance, because that is not fair to the applicant either.
I just want to just point out an observation. Since I've been the chairman of the commission, and Stuart, I'm sure as the mayor, you get this all the time, but I get calls now. People know who the chairman is. They see in writing and on TV. And quite often it's sniffing around about projects. They want to know opinions or whatever. And I've learned this from some other wise people over the years, but my response is always, the planning commission is a deliberative body.
Right.
The individuals really don't have standing. All of our work has to be done here in front of the public. We can't deal with these things, give opinions, exert influence, whatever the case may be, individually away from the table.
Correct. For example, you might just be going for a walk in a park, or say you're at one of the downtown restaurants for dinner, and there is a project in a particular neighborhood, and a few of the neighbors very well know who the board members are. They walk up to you and they start asking you details of the project, or giving you information about this project is not going to be good because the fence is too close to the property line. Those kind of issues are classified under the law as something called ex parte communications. Ex parte communications are not legal. The reason they are not legal is because one commissioner is getting the benefit of information that the rest of the commissioners don't have. So if somebody approaches you, I know these are people who you see on a regular basis too. So it's not like you can just tell them, I'm not going to talk to you. What you can suggest to them is, if you have any valid information, we would really appreciate it if you came to the public meeting and presented that information, or wrote a letter to the city for the record, so that all the commissioners have the benefit of the same information while making a decision. Say a project comes before you, now maybe Dennis and maybe Matt know what the neighbor's feeling is. The rest of the commissioners have no idea what you're talking about when you're mentioning, I know this is going to be a problem. So do not discuss a proposal with an applicant, neighbors, or other officials outside of a meeting. A general conversation on planning aspects is fine, but the specific details of a project must be done in a public forum, so all of you have the benefit of having the same information before you when you render a decision. And don't let anybody know what your opinion or a decision is. Yes or no because you never know. At a meeting, somebody might present information that none of us were aware of before that might totally change maybe the planner's recommendation or what you had decided in your mind. So if you have an opinion about something, keep it to yourself till you have the benefit of all the information in a public meeting. That is very, very important, because if a project gets denied, and it is a project in which an applicant has invested a significant amount of money in preparing the documents, the plans to come before you, that's the first thing the applicant is going to do. They're going to go back and check if you followed the rules and procedures, if you used some information that you got to render a decision which the applicant was not aware of, because that information was given to you privately and not in a public meeting.
I have one other thing on this before meeting subject. It's generally my practice when we get the agenda and I see the items, I go to the sites.
Mm-hmm.
I think it's important to go to the site as a commissioner, get out of the car, walk around, make sure you understand physically as best you can, you know, the site that's been requested, but also what's around it. Is there any limitation on that? I mean, I'm doing that individually, obviously.
No, that's a good thing to do. You can visit the site, and while you're visiting the site, it might so happen that the neighbors might come and talk to you, tell you stuff. You can't stop them from talking. It's okay, they can talk, but do not give them a response or show what your opinion is of the information they have shared. You know, you can listen to them and you can tell them all this information should be presented in a public meeting so all of the commissioners are aware of it.
Just so the newer members know, I mean, I don't demand access to the property or anything like that. I mean, I just go and look as best I can. And there's been a couple times where I've met the petitioner and they said, well, sure, come in and look around. But otherwise, it's simply becoming physically familiar with the item.
This is a big challenge, more so for the Board of Zoning Appeals or the Zoning Board of Appeals. I mean, they generally have to visit the site. It is reasonable because they are trying to see if somebody is asking for a variance, what exactly are you saying you cannot meet? And people are going to come out, the homeowner is going to come out there and try to push forth their project, or the neighbors, if they are opposed, are going to try to push. So for ZBA members, it's very, very important. They absolutely engage in no conversation. They just go out there, take their own notes, make their own observations and leave. So next slide, please, Siona. When making effective decisions, always make findings of fact. Very, very important. If you approved or you denied something, why did you do it? That's important, which is why when you approve a site plan, you refer to the planner's letter dated this. That becomes part of the record as a finding of fact. You have to consistently apply all the standards. Apply conditions only where appropriate. Do not impose conditions unrelated to the project, because that wouldn't be reasonable, and that would be towing a line that might get you into trouble. The motions must be very clear. You don't want an applicant to afterwards reach out to staff and say, I really didn't understand what that decision was. Your decision should be very clear. And if any of the if a motion is made and any of the other commissioners have a doubt, please do not hesitate to ask the secretary to read back the motion to you so that you understand clearly what you're voting for. If there is a project where there is possible different votes coming and others, say 3 members vote to approve and you vote to deny, state the reasoning behind your vote. Let them know what is the reason why you're going to go against the motion that is there. Once again, accurate and complete records, that is the responsibility of the secretary who serves on the planning commission, and also administrative staff to make sure there are records of all the paperwork that has been submitted. Maintaining minutes to ensure that they are publicly available, because that is subject to any of the documents submitted is subject to FOIA, and public meeting minutes should be available for all residents and anybody who wants to go on there and basically see how the meeting went and what was the decision-making process. Next slide, please, Siona. Now, incorrect reasons to approve or deny. Very important. No one came to object, or many people came to object. Neither one is a good enough reason to approve or deny. A thing that I've seen very, very often, a company or a business will come and they'll say, I'll just throw it out there, BP gas station, they'll say, oh, my sign is big, but it's neon orange, but this is the only sign building model we make. Corporate will not agree to anything else. And that is not true. Because when Walmart first started building their buildings, they used to, I think all the commissioners would remember, it used to be gray color drive-it walls with that blue color on top. It is when communities started saying, no, either brick or you don't need to build. And today, literally every Walmart is built mostly brick. So there is no such fixed thing as corporate is not going to change. If the business really wants to be there and it happens to be a chain entity, they will make the changes necessary to comply to your ordinance. Reasons not to approve or deny: the ordinance is too strict. If the ordinance is too strict, you can always do a zoning text amendment in order to change the regulations, but that is no reason to approve or deny if somebody is not meeting it. Another thing, we have to give it to them or they will leave. Sometimes you will have developers approaching you saying, this building has remained vacant for 3 years. Considering the economy, you should be grateful we are bringing anything to you. That's not a good reason. As long as they meet the standards, the city should work with them to try to get them in. The my way or the highway kind of decision making is not reasonable. It will make the area better. Yes, a project might make the area better, but then that is subjective too. I mean, a project that seems really good for some people might not be so great for others. So if you apply the standards consistently, if the use is good, that's fine. If not, it's not coming in. Personally knowing an applicant, in smaller communities, you have a developer who will do a lot of projects. They have built a certain level of trust with the community, which is wonderful. But that should not be the reason for saying yes to a project that does not meet the standards. And finally, I just don't like the way it looks. We all have our individual opinions. We have our ideas of what looks good, what doesn't look good, but our personal opinions are not important. What is important is, does it meet the standard? Does it meet the vision of the community? If yes, we go forward. Presenting your thoughts and your suggestions is always welcome. If you think there is a particular change that can be made in a building architecture that will enhance the architecture, Commissioner Gasson has often come up with like really good ideas for what changes could possibly be made. And when an applicant says, structurally this is not feasible, some of the commissioners have chimed in and said, well, you could do this and it would still work. And the applicant has been amenable to it. So always feel free to make suggestions and, discuss and possible changes to it, but within the realm of the ordinance. Like if the ordinance says, we expect masonry material and the applicant is proposing really good brick, the commission cannot say, I want this whole site to be stone, otherwise I'm not going to approve it. So, you can suggest, we think a little mix of brick and stone would probably be a better accent on the building. Next slide, please, Siona. Managing different opinions. There are always going to be differing opinions. Typically, when people oppose a project, they are most likely to show up at your meetings. Those who support a meeting rarely show up at a meeting. Many of your projects go through, you have nobody in the audience to speak for it. It's not basically that nobody cared about the project. It's just that, they are fine with it. They do not have typically people who object are the ones who show up at a meeting. Very rarely does somebody take the time out to come and say, oh, I think it's a fabulous project. That happens very rarely. Public pressure should not be the only reason for approval or denial. And that is something the Rochester Planning Commission and City Council face a lot of. You do face a lot of public pressure. And it has got to be very challenging, the position you're in. And it's difficult too, but rational thought does need to prevail. Your master plan and your zoning ordinance, they reflect the community. They are not just documents that were written by the planner and just adopted by your city council. Every zoning amendments that is put in place or the master plan, it involves a lot of work from the Planning Commission and the City Council, who are the appointed and elected representatives at the community. So you have a city of thousands of people. If 30, 40 people show up to oppose, it doesn't mean your master plan and your zoning ordinance was approved without anybody's liking. It was a community-wide document that was put in place. Yes, there will always be some people who do not like what the regulations are, but that shouldn't be the reason why you approve or deny a project. You must consistently follow the law and the written rules of procedure, which means if you have a public hearing, give the public an ample opportunity to speak. At the same time, the public cannot monopolize. You cannot have one member of the audience repeatedly come and, bash up on a project or overtly support a project. A public hearing should give a reasonable platform for all members of the public to speak. They are welcome to come and present their points, and the chair should control that. You should, depending upon how many of the public turn out, you give 3 to 5 minutes for them to present their salient points. If it's a more contentious project, maybe the entire neighborhood group can get together, elect a representative, and that representative can come and put forth all their points or whatever their concerns are. So procedures must be followed. It shouldn't be that one person gets to monopolize the microphone in a public hearing for half an hour, and the hearing has gone on for so long that the later people get 2 to 3 minutes to speak their part. Next slide, please, Siona. So what about special projects? This is one of the biggest things that we have in Rochester. Now, special projects is an optional flexible tool. And I have seen at the Planning Commission meetings, sometimes we have had residents come up and say, special projects is an excuse for all sorts of projects to be approved and only Rochester does it. That is not exactly true. It is called special projects in Rochester, but it's very similar to another developmental tool called planned unit development, which is there just about every zoning ordinance that you have for almost any community that we have worked for. Planned unit development is a tool. It is a very elaborate tool. A special project's approval is a slightly abridged, but it's very, very similar to a PUD. A PUD can also be pretty much built in any zoning district. So you're not doing something that is outside the realm of the law. It's just that special projects is a terminology that is unique to Rochester, and it's set up slightly different than a PUD, but it's still legal. It is a type of development process. It is a regulatory process. And the reason you have this similar to a PUD is to allow for very innovative and unique kind of development projects that would otherwise not be allowed under the existing zoning. For instance, take the Blossom Mills project. That property is zoned I-1. Under the current I-1 Industrial 1 zoning, all you could put in there is warehouses, manufacturing, industrial operations. Pretty much no other use could be put in. If you had it as a PUD, if we had a PUD process in our ordinance or the special projects, you're actually getting a senior housing development over there, 55 and Boulder is what they called it, which provides for a need in the community as the population is aging across various communities and across the country. And as we have seen from the recent, what is going on currently, people want to have their parents and their aging parents close by, maybe not necessarily in an old age home, but maybe in an assisted or an independent living that is close by where they can keep an eye on them. These kind of developments provide for that niche. It can also be used to promote certain kinds of development patterns of projects such as cluster housing or adaptive reuse. You could use the special projects if a developer comes forth with an affordable housing or attainable housing. If they come forth with a project, the special projects is a fantastic tool that you can use to make it happen. Next slide, please, Siona. We do have some regulations for how and when special projects can be done. PUDs typically in most communities are allowed anywhere within the municipal boundaries. But in our case, a special project
Can anyone hear me?
I can.
Okay.
Guess that's the end, huh?
Might be.
I think she's gone. Like, I think she lost power or something.
Yeah.
She had a look on her face and then she disappeared.
Got to have the sound decision making.
Yes.
Requirements. Be careful what you say. Next slide, Shiona. Yeah, I'm a teacher, right? I can do this.
You can do this. There's only a couple left. I would imagine she's frantically trying to get back on. Siona, are you there?
I am here, and I'm also texting video to see what happened.
Okay.
Sound decision making. That's what we need to do, right?
We're really moving along now. Progress break down.
Next slide,
Okay,
Siona.
Matt, you got the next slide.
Next slide, Siona. I thought everything was based on my opinion and not on facts, right?
Till your wife gets involved.
Yeah, there you go.
We could always add her just by phone if she's having internet trouble.
Yeah,
Okay.
well, I'm waiting for her to respond.
I'm back. Can you hear me?
Hi,
Yeah, he's back.
I'm so sorry. Can you hear me?
Yeah.
Yes.
My laptop crashed. I apologize. It just went completely blank, and so I had to jump onto my desktop. So I apologize for that.
Okay.
I apologize for that. So with regard to sound decision making, the
Okay.
city has more flexibility when you decide special projects, but that does not mean everything is a judgment call. And that is why we have requirements in our, yeah, I think we jumped a slide, yes. We follow the ordinance requirements. It's important that when we do a special project, we treat all applicants as consistently as possible. Like applications need to be treated similarly. First come, first serve is not a reasonable way to render a decision, but having a decision if a certain project type is coming too often before you, you can have more questions, but you have to try overall to try to balance. If there's a multiple family project, it needs to be measured the same way that you have applied to previous projects. If for some reason you're wanting to render a different decision on a special project, you need to make sure why you're rendering a different decision. There has to be a reasonable basis. And that decision has to be based on findings of fact and not opinions. The next slide will actually explain what exactly this findings of fact is. Next slide, please, Siona. Okay, for example, the difference between facts and opinions, sometimes the line gets blurred. So we have projects, I'll go to the last one. This will create too much traffic. That is a statement, but that doesn't really tell the applicant, okay, it's going to create traffic. Yes, if there is a vacant lot and now you're putting a building on it with cars coming and going, it is going to have traffic. What you actually should possibly say is the project will only provide one entry and exit point, which is going to push all the traffic onto one already crowded road. I would like to see the applicant explore options for diffusing traffic by providing another entrance. So when you have a comment on a project for a change, if there is a major issue of concern on a project, the Planning Commission to try to offer some amount of constructive criticism. If you think there is an issue, why is it an issue? If you're saying traffic is too much, why? This would be a reason. For instance, a project comes, you're like, presently the road is already got rush hour traffic and the delay at the light from personal observation is 5 minutes. You're adding 120 more cars. What is it going to do to that traffic? How is it going to affect it between the morning hours? The questions have to be pointed. Just, making a statement. The neighbors do not want a tall building. Well, I'm sure in many cases the neighbors would prefer a park with deer, but that's, that does not balance out with personal property rights. Instead, you could say the buildings in this area are overall of a lower height. Can you reduce the number of floors? That was the kind of constructive criticism you gave recently to a project that came on Main Street. The Planning Commission said, yes, the building is nice, but it's not appropriate for its setting because everything around you is of a lower height and your taller height will overwhelm everything else in downtown. So that was constructive feedback to the applicant. So when there is a major concern or an issue of concern, make sure the feedback you're giving is fact-based and not opinions like, I just don't like this project. So that is very, very important. Next slide, please. Finally, questions and answers. So from the first slide, communities are susceptible to litigation. Municipalities are. That is a given. In our society today, it is just the way planning works, and it just happens to be the way of life, I guess. But what we have to do is we have to try to minimize the risk to the community. That is the goal of the planner, the city attorney. Our goal is to help you make those decisions based on what the ordinance says and what the facts are. It is your responsibility to balance out the feedback you receive from the public. Sometimes there will be a project that receives overwhelming public opposition. As a planner, I will evaluate those reasons for opposition. And I might say, yes, this project is not going to work because the points presented by the residents or the neighbors have a valid merit, which does not show up in the original application. At other times, even if 10 people speak against the project, I might still go ahead and stick with my original recommendation for approval because the basis for the neighbors opposing it is they just don't want anything over there. And that is not reasonable either. So my recommendation to the Planning Commission is before every meeting, make sure to peruse all the materials that are in your packet. If you have any questions, make sure you write them down so that you will be able to put forth a clear concern and get the answers. If while making a decision on a project, you're unsure or you need more information, please do not hesitate to ask the applicant to provide that information. And always balance out public opinion with what the actual facts of the case are. In case of a principal permitted use, if the project meets the ordinance standards, you must approve. You cannot deny it. In case of a special project or a special exception use, yes, you can deny it or you can approve with conditions. If you approve with conditions, make sure the conditions are tied to that specific project. And if you deny, make sure you clearly state what your reasons for denial are, because that is reasonable too. So do you have any questions for me, please?
Any questions for video? That was very helpful, very concise. We appreciate that.
Dennis,
Actually-
I do have one question.
Patty,
Yeah, so Vidya, only with the planner, with these special projects, we can approve with exceptions.
Yes.
Okay,
Yes.
only with that. All right.
Only special projects are the only tool for which you can approve a project that does not meet the specific requirements of the ordinance itself. In case of everything else, if they don't meet the standards, they go for a variance.
But I mean, we can request.
You could I'm sorry, could you?
We can request accept, like we can request like we'll say, okay, we approve this once, you know, this item or this item or this item are, like if we have questions about specific items in what they're doing, like, you know, that like in parking, you know, we would like that clarified, we'd like this.
Right.
Is that what you're referring
to? In case of a special
to?
project, you can ask for all the clarification and then you can grant the exception. But in case of a principal permitted use or a special exception use that is allowed by the ordinance, they must meet. If the parking requirement is 10 spaces, they have to provide 10. If they're providing 8, they will have to go before the Zoning Board of Appeals and seek a variance for those 2 spaces.
Right.
And it's always important that the Planning Commission provides some feedback. If there is a project that comes before the Planning Commission and needs a variance, it's important for the Planning Commission to provide some feedback that the Board of Zoning Appeals can use. Are you supportive of, you know, if the applicant is going to have only 1 customer per hour, do they really need 20 spaces? You know, maybe the 15 they provide are okay. So that kind of feedback is helpful for the Board of Zoning Appeals to make their decision too.
any other questions? Thank you very much for putting that on. We appreciate it, Biddy.
And my apologies. I have 3 computers here and 2 of them crashed on me. So,
What happened? The battery die on you?
yes, the battery died. I used the bigger screen. I borrowed my husband's computer because it's got more firewalls on it. But the battery just died on me, even though I have it hooked up to the power source. So I jumped onto my desktop. Sorry about
Blame
that.
the kids. Blame the kids. Okay, the next item, number 6, introduction to infill development. Vidya, that one is yours as well.
Yes, I will provide an introduction, Chairman McGee, and then I will hand it off to Julie Koniki, my colleague. She's the principal planner too.
Okay.
So infill development is something that has been on the Planning Commission's radar for, I think it's going on almost 2 years now. There has been a lot of concern about infill projects, about homes being bought and being torn down and being replaced with structures that are too big, seem to meet all the ordinance standards, yet they appear too big. It's a question of building mass. There was a question, what happens to basement egress windows? Do they count as structures? Do they have to meet setbacks? What about cantilevers? Are they subject to setbacks? What kind of encroachments are permitted in the side yards, in the rear yards? What about impervious surface? There were a lot of questions the Planning Commission had, and there's no real easy answer to that. And we had to analyze our existing ordinance, tell you what is there, tell you what other communities do out there, and then basically get your feedback on what you would like to do. Because infill is such a tricky thing because it affects residential properties. Not everybody is going to be happy with what is going to be done or with what exists. But the Planning Commission needs to look at the overall picture and decide which way you want to go. Do you want to make a change? Do you not want to make a change? Do you want to keep it as it is? Or do you just want to make a minor tweak? And what we did is we decided we have to initiate, we have been having a lot of internal meetings. We have met with Blaine and Nick and Siona. We have discussed various specific properties. Extensive research has been done to put together the infill report that is in your packet tonight. And I will hand it over to Julie because Julie and Natalie were the ones who have actually worked extensively on it and done neighboring research. I will also be here to pitch in and answer any questions that might come up. So having said that, I'm going to introduce you to Julie. I'm not sure how many of the commission members have seen Julie before. She's appeared before City Council as part of Team Rochester. But if you haven't, Julie is a principal planner who joined McKenna several months ago, and she's an invaluable asset to our team. So Julie, you take it away from here, please.
Great. Thank you, Vidya, for that introduction. Good evening, commissioners. It's nice to finally get a chance to interact with all of you. I think some of you have seen my face, but we haven't really gotten a chance to dig into an issue together. So I'm really excited for that. I joined McKenna back in January. I've been an urban planner for a little over 7 years now, and my background's in architecture. So these issues where we're looking at kind of the nuances of how zoning ordinances inform design and how design fits in context is really right up my alley and something I really love.
Are you an architect?
I am not a registered architect, no.
Okay.
I do urban design and planning now. I'm more on this side of things. But I certainly have that eye and that background and bring that into the ordinances I do write. And I do a fair bit of form-based code to kind of that end to bring that experience into my work. What we're going to do for you tonight is break up this report into 2 halves, essentially, just to make sure that we have plenty of time to discuss each issue in more detail. So I'm going to go through these first 3 issues that were in the report. I'm hopefully not going to just kind of restate what was in there for you. Hopefully you got a chance to look it over and really dig into it. I know there was a ton of information there, but that's why Vidya and I are here to kind of steer this dialogue. And like she said, you know, this is about figuring out what changes really need to be made and what changes don't. It's not necessarily about us telling you exactly how to do it yet or giving you our recommendation as planners is this or it's not this, right? Zoning ordinances aren't always cut and dry. And even if we have a preference or a precedent as planners from our experience, we're always going to tailor it to kind of the unique needs and situations of a community. So that said, I'm going to start with issue number 1. These are really ordered, I think, to kind of facilitate this discussion well. So issue number 1, if you are following along in the report, it's on page 5. It's the foundation really for everything else we're going to discuss. Changes to an ordinance create nonconformities. This is a drumbeat that we've heard for quite a few months now. And it creates a roadblock to wanting to make any kinds of changes when there's that uncertainty out there about, well, just how many properties this is going to affect, right? And I believe Attorney Kratt issued a cover memo that sort of touched on some of these kind of underlying legal issues when we're making changes to the zoning ordinance, and he certainly helped us frame the discussion here for you. So,
Julie, before you move on, this is Blaine. Would you be able to share your screen, or can Siona actually pull it up? Whatever is easiest, just so that everybody can kind of have it in front of them.
Yeah, I actually was just about to do that. I thought Julie was going to share her screen. And
I can
okay.
I could do it, Siona.
Thank you. Mm-hmm.
All right. So you're all seeing the report now?
That's correct.
Okay, great. So this is something that we kind of heard right off the bat as being kind of a major roadblock to even beginning this discussion, right? And what happens is when you make changes to a zoning ordinance, it's going to create a nonconformity somewhere. And there are two kind of ways that you can get out ahead of this for yourself to give yourself a little bit of a peace of mind that what you're doing is fully legal, that property is affected are still going to be operated as is, or even make minor changes when you move forward. And it kind of bridges that gap between I need to go out and look at every single infill housing project that's been approved since the ordinance was introduced, right? And count up the nonconformities. I mean, that's just not time or budget effective. So in lieu of that, we have kind of these built-in tools as planners to do this through your ordinance. So the first is to draft a purpose and applicability section. All this is really doing for you is saying what exactly the standards apply to. Right now, there's a definition for infill development that sort of gets at, well, which houses would be subject to the regulations in here and which wouldn't be. But you could certainly craft kind of better statements that specifically call out what infill development is, and if certain infill projects, say perhaps an addition, should be treated differently than other infill projects like a tear down and rebuild. So this just kind of sets the stage for people when they flip to the ordinance, they know exactly if the act they're doing applies to these standards, and if so, if all of them apply, if only some of them apply, or anything like that. The second is having a purpose statement. Now this is something, it sets the legal foundation for the regulations. Now, generally speaking, with an ordinance like this, you do want to have a purpose statement. It should tie back to your master plan, and it lays the groundwork for why what the city is doing in terms of its regulation is within the city's legal rights in terms of the types of zoning regulations it can put in place. And I believe Attorney Kratt gave you a good example of how a purpose statement like that might be written. So this one's not so related to the nonconformity issue, but these are kind of the legal underpinning issues that you might want to address before moving forward. And in this case, you could tailor that purpose statement to explicitly drive at maybe new issues that you're going to introduce that aren't there. So that really helps when you get legal challenges about your ordinance, because you can say this statement right here clearly demonstrates that we are within our legal rights and that all of the standards in the plan tie back to our master plan. That's just good kind of legal foundation for your regulations. And the second part of this is in that kind of introductory section to the actual ordinance standards is to specify how previously approved infill projects should be handled. And this would also actually extend because infill housing in Rochester also applies to just an existing home that's been there for maybe 50 years that is doing a larger renovation. It's also going to apply to that too. So if a change to this ordinance then causes those projects that would otherwise, be applicable to this section or were previously approved under it, that's why most municipalities have non-conforming sections of their ordinance. These protect property owners from these kind of routine changes to ordinances that cause a non-conformity to happen. So I took a look at section 406 of the Rochester zoning ordinance, and it allows for the continuation of a non-conforming structure, provided that the existing non-conformity isn't expanded. This is pretty typical. So for most property owners, this is protection enough. This is going to allow them to continue the use of the property exactly as is and make a lot of upgrades or renovations to the ordinance without being negatively impacted. That said, we understand that, you know, we've heard a couple of times that banks don't have the same understanding of what it means to have a non-conforming property that we do as professional planners, and they may unfairly penalize homeowners, and that's a very valid concern when just choosing to kind of deal with this in the same way that it's currently being dealt with through your non-conforming structures section of the ordinance. So as another option, we started talking to Attorney Kratt about, is there another way that we could grandfather in existing infill homes as permitted but legally conforming uses and structures? Now, this is something that, you know, he can kind of weigh in on to give you a little bit more of a legal foundation. It's really just a kind of a minor difference and maybe even semantics in terms of how we would think about things legally, but in terms of property owners and banks, and maybe even for your peace of mind and the council's peace of mind, it could be something to explore. And that basically allows pre-existing non-conforming structures that they would be considered conforming. So you would no longer have that little non-conforming tag attached to the house, even though for all intents and purposes, you'd probably put similar provisions on a structure. So I'm going to stop it right there. Yeah.
My concern would be if we grandfather them all in, that the next person will try to use what are now considered conforming buildings for their next application. And, you know, for essentially an odd building that matches one of these that got grandfathered in, and we wouldn't want that. So there'd have to be a stop, so to speak. And obviously I don't know how to do that legally, where someone can't use the grandfathered buildings as the basis for a future application for something that we would continue to consider non-conforming.
Let me just try to restate that back to you so I make sure I understand your question. So you're saying that a previously approved infill home, we would grandfather in as conforming.
Even though we wouldn't want it in the future.
Even though you wouldn't want it in the future. And then another property owner on a different site,
yes,
would point to that now conforming structure and say, I should be allowed to do what they did.
Correct.
Correct. So that's where, you know, we get into the semantics that it's really still, in terms of the legal way that it would work, it's a non-conforming structure. A new applicant needs to conform to the new standards. That's also where, going back to that applicability thing, that's where that comes into place. You could very specifically spell out in the applicability section, all new construction, you know, since the date of this, effective date of this ordinance, needs to apply to the standards here. Anything previously can exist as is, but if it was going to be torn down and new, has to apply to the new ordinance. That's why they kind of run together. You want to be very clear about who gets to continue or conform to the old rules and who has to follow the new ones.
I would just want to, you know, we'd have to get this from the attorney, but I don't know what the standards are out there or what's been found in practice. You know, does the court go along with this, or are they going to go with this new?
If I can chime in?
Yes.
It is not unusual that when new zoning regulations are adopted, that some structures or properties become non-conforming. That is the nature of zoning. when you adopt a new regulation, somebody somewhere is going to get non-conforming. So adding a caveat in the ordinance or a policy that says that all the structures before the date of adoption of this ordinance are hereby considered legal and these regulations are applicable henceforth is an accepted practice. It is something that communities do all the time. So I'm sure Attorney Kratt will be able to give an opinion on that, but it's not something that will open the city up to somebody telling you, I'm going to sue you because you let him build such a house and now you're not letting me. No,
Exactly.
ordinances keep changing, and once a new ordinance is adopted, you now have to conform to the new ordinance, and everything so far thus is considered as grandfathered in since it was legally built.
And we're pretty sure the courts would hold for the city in those cases.
Correct.
Okay. Thank you.
Back to you, Julie.
So that's kind of the end of my presentation. And I think we should kind of just stop here and have any further discussion about this first issue before moving on to the next one.
Mr. Chair.
Hi, Jeff.
Hello. Just wanted to throw a couple comments out after that, and because we did, I would say the bulk of our discussions dealt with this very issue. And I would like to say first that neither the planners nor I nor the city administration really feel that there's something should be done differently than we already have. So the non-conforming provisions are the ones that you'll see in everyone's communities and their zoning ordinances, and those are very standard. So there really isn't a need to change the way we handle non-conforming. So the reason why Julie and Vidya and I are discussing this gray area, if you will, or what to call something a little different is purely to have discussion as to whether or not we even need to go down that route. You know, if there's a couple of situations where a bank doesn't like the fact that it's, you know, that this house is considered a pre-existing non-conforming house, for instance, you know, it's really only dealing with a certain aspect of it, right? Whether it's a setback, whether it's a height issue. So, you know, I don't think it's as big of a problem, and I don't think the planners do either. But they're just reporting back as to what they've heard as to if a bank considers something to be, or hears that a house is non-conforming, they get worried that if it gets knocked down, they can't rebuild it, and their security is lost.
Because this will show up in a title search, won't it?
I don't think so, because it really is a matter of because the house is legal when it was built, right? And that's the presumption. It starts that as, and only because the city of Rochester zoning ordinance changed subsequently would that component of that house no longer be permitted. That's why it would be considered a pre-existing, because it existed before the zoning change, and it'd be legal because it was legal at the time. So no one is forcing that homeowner to change anything about their house now. And what Julie had said before is, let's say there's a non-conforming garage because it was, you know, 1 foot away from the property line, and now we require 3 feet. Okay, that would be a non-conforming structure. So what that would say is if that was completely knocked down, they would have to move it off the line and be compliant with the current zoning, and they couldn't double the size of the garage, you know, if it was continuing to be, or it was increased into the setback, recorded setback. So they can't make the situation worse, I guess, or more non-conforming. So
to prevent them from doing remodeling, moving walls inside, deciding they want to put a different roof on, just things like that.
No, generally those would be maintenance type things. Inside components are not generally a zoning issue at all. So if someone had an accessory structure that they wanted to move the walls around, like your example, that would not be prohibited. Someone would be able to prohibit. You probably wouldn't even know that your building is non-conforming, to be honest.
Mm-hmm.
Okay.
I have a question for Attorney Kratt. If we were to make a change to something like lot coverage percentage, it would create a lot of non-conformities. Would you then be concerned about the way our current ordinance is written? You say it's not really an issue now. Could it be?
Well, only not any more than really any other non-conforming situation. So lot coverage, let's say it moved from 30% down a few percentages. So there would be houses that were built right at 29.99 that, if it got moved down to say 25%. So that house can stay just like it is in perpetuity, right? So, but the issue is they couldn't add on to it without getting a variance. If it got completely wiped out by a tornado, for instance, or a demo, let's use a demo, someone takes it, they would have to then comply with it. So whether it's a lot coverage, whether it's a setback issue, whether it's a height issue, they're really all the same analysis. So yes, you may create a lot of non-conformings, which is one thing that you consider when you're deciding whether to change it. But I wouldn't let the fact that there are some non-conformities that are going to be created, I wouldn't necessarily not do a zoning ordinance amendment change for that very reason. I mean, obviously, if it's going to create, a third of the properties in the city are going to become non-conforming, well, then why are you doing it? Maybe that's the question you ask. So your question, Dean, is definitely valid, because you should see or think about what impact, how many houses are you going to make, but that type of, whether it's lot coverage, whether it's setbacks, height, all those things, you just have to wait to see what it is your goal is doing. If there's a problem that you're trying to fix, then I wouldn't worry so much about creating a nonconformity if you're fixing the perceived problem.
Mr. Chairman, it's Nick. Mind if I say something?
Please go ahead.
So if somebody built their house right now at 26%, knowing that they didn't have the money to go to 30%, now we go to 25%. By our ordinance, you can't enlarge a non-conforming use. We encourage them to be taken down. You can't perpetuate the length of that, the life of it, excuse me. So are you worried then, Jeff, about someone you took away their 4% that they had prior to this ordinance?
Well, they haven't exercised that right. I mean, that happened. I'm not overly worried about that because they built, they could have built to 30%. They chose not to for whatever reason, or maybe that percentage, that house was back before the zoning ordinance even was enacted. So you could have had a 20% coverage house that was from the 1920s that predated your zoning ordinance. But that doesn't mean that in perpetuity they could always go to 30%. They always have to meet the current version of the ordinance whenever they decide to alter the site.
No, I get that, but you just worry about a taking. That I do. So anyway, enough.
That's what I was trying to get at earlier when I mentioned the interior walls, but yours is a good example of, there's actually a loss, but Jeff's point is, well, they already made it through. They went through that decision and didn't choose to maximize it. Life goes on, things change.
Yep.
So they don't have that in the bank, so to speak, that 4,000 square feet.
Well, and that's right. And the same thing would be true for a use, right? So let's say you went through and the zoning ordinance changed, the districts no longer allowed, for instance, a drive-through restaurant. They would be no different from a property owner saying, wait a minute, you just took away my ability to have a drive-through restaurant when they didn't have a drive-through restaurant on there to begin with. So just because they have some rights today that they didn't exercise, the fact that those rights change, your rights secure when you pull a building permit. I mean, that's really when, the city can't change what law is applicable to them.
Okay.
And just to kind of add on, because Nick made me think of another possible scenario that's come up in other communities that I work with. So say if somebody has a house that's currently right at maybe 28% lot coverage. and we bring it down to 25%. I don't know why we would kind of lower building coverage, but say we bring it down to 25. And just given the renovations that they're doing, the nature of them, or other constrictions of the lot, they only can add on in a way that's going to increase that lot coverage or increase the nonconformity in some way. That's where you have your variance process to guide you. If someone's over a setback and they want to make an addition to that side of the house that encroaches even further into the setback, you know, they can apply for a variance, and you go through that process to determine if there is a practical difficulty there that warrants granting it, and they can still make improvements to their house. It's always going to be kind of based on the particular facts of the case, but in that case, they would be seeking a variance from the part of the ordinance that prohibits in a modification to a non-conforming structure that increases the non-conformity.
Julie, I totally disagree. If you're not asking for that, you're asking for a waiver of the 30%. And our zoning board, if we change an ordinance, they don't give a waiver. It's a self-created hardship. They will not grant that waiver based on expanding the non-conformity. It would be, you're going from 26, if you're only allowed 25 and you want to go higher, that's a numerical exception. So I disagree on that. And they're never going to get it. So
one example that we did have, Nick, was the side entry garages. There were a few properties that once the city changed the ordinance to not allow them to be in the front, that there were some that came in and said, wait a minute, this was my plan, I just haven't built it yet. So even though that restriction was, or that restriction was put into place, that the city did still allow that construction to occur.
Jeff, those weren't ZBA actions. Those were plans that were already in the building department that were issued before the ordinance got published. The ZBA has not granted one garage change at all. Zero. It won't do it.
Okay.
Just, no.
And that's valid. And Nick, this is exactly why, you know, we wanted to talk about kind of what options the city has outside of, you know, the non-conforming and variance process. And maybe that's something, this specific kind of situation that we're talking about now, when people want to make modifications that would have otherwise applied to what was there previously, maybe we put our heads around that a little bit more between now and the next conversation. But I think in most cases, and you know, this type of provision, a non-conforming provision, is going to cover people's rights as they have them right now.
Okay.
Are there any other questions or maybe just feelings about whether you think that this is something the city should be changing, or maybe we should be leaving alone?
I think we need to discuss it more. I don't feel a strong need to make this change right now, but I'm going to look to the administration and the attorney for a reaction to that comment.
Yeah, Julie, maybe you might want to just give a highlight of the second phase of this, that, you know, because this is part one of part two. So maybe at least before people maybe start to jump in, maybe
absolutely
provide a little bit more information.
Yeah, so we're going to continue this discussion over 2 council meetings. Like I said, I kind of carved out to talk about half the issues today and half the issues next week. That said, between now and next week, if there are certain things that you think warrant more discussion, or you think are missing from the report that you'd like us to work with the city administration to bring back more information to you at the next meeting, we can certainly continue this conversation. And after we're done discussing, you know, it would be my hope that we would have enough direction to figure out what amendments need to be made.
And
But
you're
if we're-
talking about
but if-
at the end of all of the discussion, not tonight.
Not tonight. So at the end of our second meeting next week, it would be my hope that we would be in that place where you could give us clear direction on what you'd like us to start drafting in terms of amendments. But if we're not at that place, we're not at that place.
Yeah, and I
right?
think really
And we can always come back.
Yeah, what you're saying is actually the June 1st meeting for the Planning Commission, just so that there's not confusion that it's the City Council meeting. This is still being discussed at the Planning Commission level, and the Planning Commission's next meeting is actually 2 weeks from now, or about a week and a half, on Monday, June 1st.
What did you plan on doing tonight?
Of beginning this discussion. So having kind of the first half of this discussion, just to
Any
break-
further in your list though, other than issue 1?
Oh yeah, we're gonna do 2 and 3.
Okay.
May I
I'd say
suggest?
go ahead and do your issues.
All right.
May I suggest, Julie, that go ahead and discuss the other 2. Put the
Yeah.
information that we have gathered so far out there. I think the commissioners need some time to digest it, get their thoughts together, and give us feedback. So
Yeah.
Julie will go through, put all the stuff out there, think it over. You have a copy of the report. Please feel free to message Julie and me all your questions and concerns, and we'll try to get them answered for the next discussion.
Very good.
Exactly. Thanks, Vidya. Yeah, I am going to do the next 2 together because they're pretty clearly related. So in terms of getting into kind of the actual standards, something we've heard come up a lot is projections, cantilevers, overhangs, what's permitted where and should it be? So the current ordinance permits architectural building features that project from just a portion of the wall to project into either the front or rear setback. And that's up to 18 inches. Our interpretation of the current ordinance is that there's no projection of any kind permitted in the side yards, and anything that runs kind of the whole vertical length of the building facade or has, I think as the ordinance describes it, a continuous building foundation is not permitted. So these standards, I think, are a little bit cumbersome in the way that they're written, and it's kind of unclear what projections are permitted where, which makes it hard to interpret. It makes it hard for property owners to know what's permitted. It makes it hard for the building department to administer this in a consistent fashion. And it's also something that I think, you might want to think about modifying in some way. So we've broken this out into kind of 2 pieces. So we think that upper floor projection, so basically anything that's going to be above clear height on your second story that projects from the building, that generally speaking is something that's going to be permitted in any yard, right? Because it's not really affecting circulation or anything. That said, we understand why the current ordinance prohibits it, right? Because the side yard setback is only 5 feet. So if you've got 18 inches and 18 inches on either side, those houses are getting really close together. You could look out your window and touch the person across from you if you want, which is what I used to do with my best girlfriend who lived next door. We could basically yell to each other through our bedroom windows. But not everybody wants that. So I think the kind of direction we'd be looking for here is more pertaining to that side yard rather than the other yards, but we can certainly talk about if you think that those encroachments in other yards should be permitted or not. The second issue that's related directly to this,
Julie, I apologize for interrupting you. If you could kindly move your slides along, because the residents are not seeing what you're talking about. So you might want to move to the next page. It's still stuck on the first page.
Oh. All right. What are you?
Move to your next page.
Move to your next page. We are all still seeing issue 1, the non-conformities. We are not seeing, so.
There we go. I accidentally paused my screen share, which I didn't even know was an option. So I'm learning new things every day. All right, we're on issue 2 now. All right, thanks, Vidya. And feel free to interject anytime. That's always fine. So that's issue 2, is about where should projections be permitted and what type. And then this is directly related to issue number 3, which is about basement egress windows. So these aren't explicitly addressed right now when we're talking about these encroachment or projection standards. These are typically, we're seeing them located in side yards a lot of times. And as just a building code issue, I don't think that it's good practice to say that it's prohibited in any yard. The interior layout of someone's house is probably driving where this is going to sit, among other kind of siting factors. And the last thing we would want to do is, put a property owner in a really bad spot by just arbitrarily saying, well, you just can't have them in the side yard. That said, the building code requires 36 inches of depth to the window well. So going back to that 5-foot setback number, that's only giving you 2 feet of a kind of walking space. Typically we'd be looking for at least 3, if not 4, in a typical kind of corridor circulation space. The building code is silent on what kind of clearance you'd need around that thing. We've talked to building code officials, we've chief for guidance about how far, we think we can push it. And, bottom line, at the end of the day, you're going to have to, build it to code. And so that's something that should be kept in mind, especially when we have houses that have fences right up along the side yard. But if it's not going to be an issue in terms of moving around that window well, we would consider that a permitted side yard encroachment. But we would want to clearly delineate the treatment of something like an egress window well from other types of architectural features projecting into the side yard that people just kind of want to have. And so that's issues 2 and 3. And I'm going to just stop it there and open it up for some questions, clarification, and further discussion on these 2.
Mr. Chairman, just so I can help add some context. So the way the city of Rochester for 26 years has applied projections in the side yard has been, they're allowed 18 inches, first floor, second floor, it doesn't matter. Only if they're attached to the ground foundation can they then not encroach in to the 5 feet. So any bay window.
You're talking about second-story cantilever.
Nope, I'm talking about first story. So the ordinance is written really poorly, uses the word nor instead of not, and the interpretation of the building officials have been a side bay window. We have them all over town. They can go into the side yard setback 18 inches. The way McKenna interpreted it was you couldn't do that. Well, that's not how forever. As this city's never, if you read it word by word, somebody put either a wrong word or meant something wrong, but the building department has issued side bay windows in for 18 inches only into the 5 feet forever. So what Julie's talking about, we'd have to clarify that if you don't want that and you only want it on the second story, then you'd have to clarify that because it's not been interpreted that way.
Could you keep going on that? What do you do with these safety windows? What do you do with second floor?
Nothing. They're not. Yeah, safety windows are code, and there's nothing against them. They're not a structure. So structures are defined as something above the ground. So the way we treated these, they're allowed in the 5 feet.
Some of these pictures we have here it looks like elaborate landscaping way beyond the functionality of the window.
Yeah, we've never had anything like that here.
And would not permit it?
You could. I mean, it's still 5 yards. It's not a structure, so you could do that.
Mm-hmm.
Well, like the one's got a planter box in it.
Doesn't matter. It's not a structure.
Mm-hmm.
And that looks, the one lower right looks like the typical functional one I've seen.
Right.
Mm-hmm.
But the top 2 look like architectural features built around the windows. That's okay?
According to the ordinance today, yes.
Okay.
Mr. Chair. Nick, you can correct me, but I think that when we say that they could have those and it doesn't count as a structure, the building official had said that, well, as long as it was at grade, right?
That's
We're
correct.
not talking about something that was, 2 feet above grade.
So these 4 then would be permitted.
Yes.
Yeah, the top left is the
Top
closest.
left, I think is pushing it, but
Yeah.
that's exactly why we showed the
Yeah.
range of images.
I would say the other ones are pretty much at grade.
Nick, have we had any, Nick and Jeff, any lawsuits? I mean, when existing neighbors really object to these kinds of things, whether it's cantilevers or safety windows, have we had any lawsuits?
Not since I've been here.
No, the cantilever I don't think has been much of an issue. At least people may say that, hey, I don't like this, and then Nick points out or the building official points out that that's okay, and I think that kind of goes away. There was a real there's a real big dispute with one house a few years ago, but the egress window projecting out like one of these was one of the several issues that happened. So there was no litigation that I'm aware of. One that was, I guess, threatening litigation against the neighbor, but not against, not against.
Yeah, Mayor, do you remember Mary? Somebody Mary on University.
Antonucci.
Yes, no, not Mary Antonucci. Mary, she was on the zoning board of appeals. She lived on University. Her and her neighbor got a huge fight, and the city got involved. It might have been a generator, or was it a window? It wasn't a window well. It was on University, Wilson, where Marilyn Trent lives now.
Yeah, Mary Wilson.
Yeah, Mary Wilson. That's it.
They built the right next to her. They built that office building.
Ah, that's it.
And then they put the air conditioner on the side right next to there, where it was like making noise all night long.
Yeah, that's it.
Bought it, and we used to call it the Wilson affair.
You're right. I remember that now.
So I have a couple questions or comments. First of all, based on our current ordinance, it essentially means that these egress windows can be built right up to the property line, correct? There's no limitation on them.
Correct.
Okay, well, that seems kind of ridiculous, but and then as far as cantilevers go, the concern that I have is what it does to hardscaping the whole property. So, first of all, yeah, it's a bit of a intrusion into the setback, which may upset a neighbor. But beyond that, it's also creating more water runoff that can't naturally perk, and has to be dealt with by the storm sewer system, or can run off into a neighbor's yard or various other issues. So that's the concern I have over these two particular issues.
Dean, just so you know, so the cantilever can't touch the ground. So in theory, you're right. There's more runoff because there's another surface up in the air, but it doesn't. If it goes to the ground, then it can't do that. Like a chimney can't stick out into that. So
no, I understand, but the water is not going to get underneath the cantilever.
Right.
Unless there's wind or something, but for the most part, it's going to find its way through the drainage system.
Yeah, I got you. Yep, I agree.
And Dean, to your point on these sort of ones, so in the picture, like this is Blaine from city manager.
We've heard of you before.
Yep. The bottom, that's good. On the bottom left, if that went right up to a fence, I'm concerned that our police and fire, if there ever was an incident, could fall in right up there and not visible. So
how about two abutting ones on neighbors, and you can't get past it?
Yeah. So
you can't even walk around your property.
Yeah, there's a safety concern, and I was aware of in Illinois a police officer who actually became a quadriplegic because there was a call for a break-in, and this police officer did not know and fell in and actually broke his neck.
Oh.
So
aren't these graded in some communities? Many of these I've seen have a grade level.
You can have animals living in there too.
Generally, they have a lid that there's a component of it in a part of the building code requirement.
Yeah, I've seen the kind of like a plastic bubble that's kind of gone over.
Or actually iron grates.
Yeah, it comes in a couple forms, an iron grate or, like a polycarbonate. cover that you could actually stand on.
Mhm.
But I think
Do
that's
we require
only in the
that?
building code.
Do we
Is that
require
required?
I
I do not think so.
David Gasson. I hear the comments being made, and I appreciate that. But maybe some of this sounds like rebutting that, but it's really not meant to be that way. But I see it from another way as well. So the idea that a window well or a escape window
It's for safety.
thing,
Yeah.
I could see that a police or fire could fall into it. But the purpose of it is that so a resident occupant can safely get out. So there is a side to that. It's a hazard, but it's also a safety element to the house.
Mhm.
So I wouldn't be too quick to say that's not a good idea. I think it has to be practical, maybe not to the property line. And I don't know how you squeeze that into the ordinance or you just let it ride with the building code, which I think is probably the best way to do it. On the other thing, projections, I always had a thought about this is when I look at Rochester and what in housing, what makes it interesting and gives it real character, especially some of the older houses or the newer houses that are meant to look like they've been there for a while. It's these kind of elements that bring it to charm.
Yeah.
It's a dormer on the second floor or one at the first floor. I'd hate to restrict an element that brings that element of charm where you'd wind up with a bunch of straight sidewall buildings maximizing square footage because that's the way they can do it. I wouldn't be real easy in wanting to take that away. I see the point. I think it was Nick saying maybe at the second floor it's more appropriate versus the first floor because it does infringe on the 5-foot setback for passageway if you have two that are directly opposing each other. But I think we have to be very cautious about saying, let's not do that because it does add what I believe is a great deal of charm to the housing stock. Part of it is it kind of hoods the ground from getting water to it. I think the roof eave itself right above one of those projections does the same thing. So if we're really, I mean, that's a concern, but I think there's where do you draw the line on that? If you go up to the roof and say you have to have no soffit, no overhang, again, that goes back to the character and charm of a house, well, whether it's what we see in Rochester or not. It would look really odd if we didn't have overhangs.
I think I should put some context on my comments just so nobody's misunderstanding. I'm not saying none of these things should be done. I think they're all wonderful things, but they should be done with an understanding that there's issues that come along with them. First of all, if you're going to be adding these elements and you're going to be hardscaping from an aerial perspective, the vast majority of your property, there are issues that are created. So if you want those things, that's great, but maybe you can't have other things like a driveway or a concrete patio that covers 90% of your backyard or whatever it is. I'm just saying that we should look at it holistically and not just say, well, this is a good element, we should keep it. And this also is a good element, we should keep it. Because then when you add all these good elements together, you might end up with something that is a problem, even though each one is good individually.
Great point.
Well, we don't have an impervious coverage
ordinance.
That's my point.
Yeah. Which that would take care of that.
Some communities do require that when you have egress windows for the basement that comes into side yards, that it needs to have a cover on it. The cover does help prevent situations where, public safety or somebody walking in the dark can fall into these holes. Might be
Or
just
animals living in it.
Yeah, exactly. Or raccoons or something, or even the dog or the pup falling into it. They do require window covers for these, and those covers can be easily opened and you can get out of it. It's like just push from the inside and it goes up. So I don't know if that is something that could also be considered for the safety aspect.
Yeah.
I'm assuming the National Building Code has minimum dimension sizes for these
yes
escape windows.
Yes.
Yes, 36
3 of these
inches,
here
as
look
Julie
like
said.
three of the ones shown here look like they're way beyond the minimum requirement. The lower right looks close. The other three looks like they took the opportunity, and obviously they're going to be really close to this. The one upper right looks like it's probably 5 feet.
And I think, my purpose in showing these kind of range of options is to give you a little bit of a sense of something that isn't just kind of doing the baseline standard, right?
Yes.
I think the top two are great examples of things that probably the city would like to see, as long as, they're safe clearance around them and everything, because they're a little bit more beautiful, right, than the bottom right option. And we wouldn't necessarily want to prohibit them. But what I'm hearing is a lot of great ideas about maybe the provisions that could be put on these things to allow for them. So I think we could strongly encourage be located in rear yards wherever possible if the clearance between the edge of the building and the property line is only 5 feet. I think you could say we would encourage the applicant to explore putting it not in the side yard. But if it has to be in the side yard, perhaps require a cover and say it can only go 36 inches into the side yard. We wouldn't allow it just to do whatever. That's exactly why, it not being in the code is a problem, right? Because right now, Nick doesn't have, kind of hard and fast rules about how to approve or deny things. He's just saying, well, it's a requirement. I have to make a reasonable accommodation with it, which is absolutely right. But you could certainly kind of put some parameters in place to guide property owners into doing something that's safe, that's attractive, and that's not going to be too much of a safety hazard if it's in a tight side yard.
Yeah, good point.
Can I make one more point that hasn't been discussed regarding this issue?
Absolutely.
The one thing we haven't talked about is the difficulty that a contractor would have in going right to the edge of a property line to build one of these structures without undermining the integrity of the abutting property. If someone's got a fence there, or if someone has a walkway or some other architectural element there on their property, then you start running into how do we handle that as a municipality? Are we responsible to protect the resident, or does it become a legal issue between a contractor and one of our residents?
So this is something that Jeff actually brought up and added to the end of this report, which we'll probably get into more at our next meeting, but I can, it kind of jogged my memory to look into it a little bit more. This is something that he raised, and I think he brought up somebody who had a lot of issues with a neighboring property owner, kind of damaging, causing dust, just being really disrespectful to their property. You have tight lots, it's bound to happen. And I believe it was mentioned during that discussion that, one, it's probably something you want to look at in kind of your general code of ordinances. It's something protecting adjacent property owners from disruptions or damage from construction should be something every property is afforded and not just a narrow infill issue. And then the second thing, it was mentioned that Birmingham has run into a lot of these issues and probably has some good precedents to look at for that. And I can certainly look into that between now and our next discussion on June 1st and bring back some more details on how that's structured and who bears the burden of, figuring those things out and what's kind of reasonable for the person, doing the renovation or construction to provide.
Okay.
Mr. Chairman, can I jump in? And I'm glad Dean brought this up, because the battle that I've had on my administrative side with the building official has been, we never protect the existing residents on the neighbors. I think you should have, in the municipal code, you have to drive sheet piling
Absolutely.
You're on the property line because
Sure.
I can't tell you how many. I can't tell you how many people that's Mary Antonucci. That's the folks up on Glendale. That's the 94-year-old guy on Albertson that they undermine his driveway and he can't even park on it for 6 months. And then the answer is, well, the code doesn't make them. They'll just replace his driveway when it's done. But I don't like that. I want us to say we err on the side of the existing residents and put it on the new builder to say sheet pile it. I don't care. Bloomingdale did that. He literally would sheet pile it so that the people didn't have to worry about losing their yard. And I hope Julie's right. Let's get that in the general court of ordinance. It was frustrating to me that I couldn't win that argument with the building guys because it didn't require it in the ordinance, and that's not right.
Yeah. No.
Good point, Nick.
So Julie, your plan is to stop now
Yep.
and pick it up the next time. So you've made our brains work here, and we appreciate that. A lot of things that just don't get considered all the time. The other thing, the point is that I want to make is that the city or the planning commission doesn't often get involved with. We don't approve the site plans for single family homes, so we see these things later. We're asked to help form the ordinances, and then Nick and his crew actually build these things, and then when the problems occur, it comes back to us. So it's probably going to take this group a little longer to get our arms around these concepts, but we'll get there. We understand it's very important.
And that's why we wanted to, break this down one at a time, but give you a real comprehensive report to take home and to study and look at yourself. And, at the back of this report, this is kind of just buffering for a second. We did look at some recently completed projects in light of the issues that we were talking about here, in light of the existing ordinance standards. And so you can find that comparison back here at the back of the report. And the one thing I will say is the kind of number one thing that we saw in this analysis that ran against the existing ordinance, not necessarily as Nick is interpreting it, but as it's written, is this issue of the side yard encroachment and the egress windows. So, I think that when we couple these kind of theoretical conversations, these technical conversations about zoning with kind of select analysis and case studies of, well, what's actually been done out there, that's how we start to zoom in on, well, how should we make tweaks if we're going to make tweaks? And I'm happy to expand this analysis if we think it needs to be, but please think about that. And if there's anything else you'd like to see in this chart or see us look at, please let Blaine and Nick know, and they can pass those comments on to us. I think that's probably the best protocol. Blaine,
Nick, I want to throw one out. These front garages, side-facing garages.
Yep.
I know they got prohibited. I don't know what the process was because I know a lot of people like that style, but it got prohibited. Should that be in this discussion again?
I would hope, because and I'll play off of Councilman Bavacqua's thought. What we did is, Vidya brought this up at another meeting. It was an unintended consequence that we have now just forced people to go 70 feet deep with a 9-foot wide driveway, all impervious, when we could have had a little courtyard in the front.
Right.
So
Yeah.
I think we never thought.
How did it come about? Because we had several of those built, and then all of a sudden that was prohibited.
I think it was initiated, Commissioner Kohler was very concerned about the fact that it seems like garage was the first and only thing you saw in homes, and it took away from the character of Rochester, which should have porches and front doors as the primary thing. That's where the conversation started, and then we went for this garage amendment over a period of almost a year it took us.
Yep.
And like Nick said, every action or every change has got a consequence. Now we do have front entrance doors and porches, but we have these long driveways going to the back and therefore more impervious surface. So it's
unless somebody objects, I would like to see that revisited in this discussion.
Yeah, it
So would
needs to be. Yeah. Agree.
I got a question or comment.
Yes, sir.
I was just gonna say, looking at these building coverages, especially like the 300 Terry on my street at 28%. Wait, when you look at it, it seems a lot bigger than that.
But then it has 41% impervious coverage.
Right. I mean, it seems like 75% coverage when you kind of just look at it. So I mean, it's really,
It's right
yeah. I
here.
mean, and it goes all the way back. So I'm just saying, it's amazing how they seem a lot. It seems a lot bigger, and I know that's what people want now, but it really is interesting how, Mayor Pro Tem Bavacqua and I've talked about, you see things on a plan and then you see things in reality, and
two different things.
Yeah, and they're usually bigger in reality than they are on the plan. Like Cedar Brook, for example.
Yeah.
So that just food for thought there.
I think in a drawing, the scale is two-dimensional. When you see it three-dimensional in real perspective, the mass just is a lot more than seeing it flat on a piece of paper. So that's definitely an.
And again, they tore down an old crummy house and put up a big, beautiful house. So I'm not complaining, but these really are huge.
Yeah. We'll see if the demand for such things comes back after our current cultural experience here.
Well,
I think it's possible that it won't.
Right.
They're saying just the opposite, Mr. Chair.
Yeah.
They're saying 30% of the people are going to leave the urban core because they got locked down.
Right.
And suburbs are vogue again. There's a big report already out on that.
Right.
I wonder, though, in the scheme of things, if we'd be considered too close to each other.
Maybe.
Well, we didn't get a lockdown like that.
Yeah. Julie, thank you very much for coming, and we'll see you in a week and a half at our next meeting to pick this up again.
Yes, thank you so much for having me. Have a great night.
We ready to move along? We're back to miscellaneous. Does
Mr. Chair,
anyone have any general discussion for the commissioners?
When you're ready, I've got 4 items for you, but I'll defer to the commissioners first.
You're on, Nick.
Okay, so I'm delighted to tell you this, that amidst our trials and tribulations now, other sectors of the economy have not put their head under the ground. And I have for June 1st, 3 things that are going to come to you for discussion items. So I talked to the mayor. I listened to when we were at the last meeting. I got the mayor's point about you all agreed, hey, if Mr. Randazzo is ready, we're not going to stop him because we have virtual meetings. So I literally, during that meeting, texted Mr. Randazzo, reached out to him, and oddly, I have not heard back from him. Sienna, I don't think you have either, which is very, very unusual with Tony. So I hope he's well. But I want you to know that we did reach out and offer, if you would like to bring forward your new plans, have video review them and do it virtually, the commission is all about that. So he has not responded, but I wanted to let you know that I listened to you and we offered for him to do that video. Okay. All right, second. So Dr. Tala, I think we're going to get him back on video. We should be able to have him for the June 1st for the upper story apartments.
Yes.
Yep. So we're going to have that one. So that's great. Then I met.
What will Dr. Atala? Is that just a continuation of his so-called master plan for his property?
Nope. This one it is technically, but he's just asking for a special exception for 2nd story apartments, and then the facade renovation for egress windows and a couple other things. So he's going to keep that separate than the master plan. This is like an existing building. He's renovating it. He has to come because he's touching the outside, not expanding it.
Which building?
Pardon me?
Which building?
It's on 134 University. It's right on University 1, where Recipes upstairs.
Yes.
In the basement from Recipes. I think it's 13 apartments in the basement and 13 on the 2nd floor. 1, 2, and 3 bedrooms in their apartments. And the ordinance does not allow that on the 2nd floor without a special exception.
Okay.
Okay, so that's number 1. Number 2, a gentleman just purchased the building on, if you could picture across, remember where Claire was at the Class Action Fitness at the corner of Wilcox and Woodward. If you make a right there and go north into the city's DPW yard, on the left was an extremely old building that's been a collision shop forever. A retired General Motors guy bought it. He has a significant classic car collection. He bought them for himself, and he wants to make it really upgrade the building with a wood front and new big windows. So it's not a car dealership. He doesn't sell anything out there. It's his private building so that he can have friends or whatever come over and enjoy what he does. He does have in order to trade vehicles, he has to have a license. So it's in an industrial district. So it's just a facade renovation. He's already started work that doesn't need planning commission approval, like replacing the rotting windows on the side. You can see scaffolding up there now. He has permits for all of that. But now that he wants to make it prettier, he has to come to the planning commission. And then it's a really bizarre situation that, if you remember on the corner, there's parking that backed up into the right of way, but it was on private property. For some reason, there's 4 spaces right in the middle of this building that are still public property. Everybody and his brother will think it's his parking, but technically has 0 parking. So he said, hey, if you want to vacate it, I'll pave it, take it over. I don't know that we need to do that. That takes a long time. So he's going to come forward, and I would like to, in one meeting, get his facade approved. So he's going to submit plans next week and shoot for the July meeting to get a 1-meeting facade renovation approval. So video, we would have to review his facade, and then if the planning commission would just give us the heads up, let us schedule that meeting for July without even seeing the plans, because it's just a facade renovation.
So he would continue to park, as the building is already done for years, in the right of way.
Exactly.
But he would need our permission to renovate the surface.
That is correct. And well, not so much. No, he could if the city said you can repave our section of the street, he could do that. He needs your approval to change the windows on the front and gussy up the building.
Yeah. Okay.
Okay. So that's that one. And then back, most of you will remember Ferndale, Glendale, Main Street. Mr. Schneider has come before the Planning Commission on 2 different occasions, got 2 different approvals. You remember the first one was 9 condos, 3 stories along Ferndale, and then 5,000 square feet of 2-story office building on Main Street. He had that approved, got engineering done. A developer came in and a purchaser came in and said, I want the whole office building and 2 condos. So Greg redesigned the whole site, and the guy backed out on him. So so then Greg just gave up. So now he's rethought it again. He wants to come and show you a presentation that will be just condos along Main Street, 3-story brownstones. The problem is it's zoned O1. So we would have to either go to a consent or to a conditional rezoning, rezone it, whatever. So I'm not sure if he'll make it for June 1st, but that would be at the July meeting. So we have those things on the horizon for you. And I know we like to put in your report, like what video, that Sienna just sent out, what's coming. There might be a couple other ones that are just discussion items only. And the last one that is going to be on the June 1st meeting is I met Wednesday under the bridge. If you can picture a diversion street, you go south, go around the curve, and there's been a for sale sign there since 1992. Same sign, literally. It says 1 acre parcel for sale. Mr. Jonathan Cranes owned that property. Somehow it's zoned O1 under the bridge. It's a little teeny sliver. It's not attached to the cement plant. So 2 gentlemen, young men, have a purchase agreement. They have a 30-day due diligence to get some feel from the Plan Commission. They have drawn up aerial views and a rough site plan and sketches that they're going to present to you on June 1st for discussion to see. It's 40 units, 4 stories, but only 2 above main. So it's the same building as Bondesk from the ground up. It's really pretty cool looking, but they want to know what you guys think before they go hard with more dollars and go into full engineering stuff.
Does it go into the grade?
It doesn't. The grade is 2 stories below main, so it's 2 stories above grade, just like Bondesk. Because if you come off that bridge it's 2 stories, you see, it's the exact same thing. It's
I'm just-
smaller, but it's pretty
Does it go into the slope though of the,
Yep. Well, yes, part of it. Yep.
okay.
Yeah. So
I'm
it's
sorry,
a neat presentation.
Is this residential or is it
Yes. Apartments. Mhm.
in an office district? Is what you're saying? The issue is it's office, right?
Right. Same thing. Now the reason they were encouraged because they looked up the master plan on our website and it showed mixed use 1, which is exactly what we wanted down there. But I had to let them know that hasn't been adopted by city council. The map isn't correct. So it's still zoned office. So we'd have to, again, find a way to do it. But they're willing to go along with that if you like the concept. It's kind of like Mr. Riley across the street. And he wanted it, before he went real hard with hundreds of thousands of dollars, he wanted your opinion, which is, he still hasn't come back yet, but same thing in this.
Are these people experienced?
Yes. Yeah, they're pretty cool. They're good guys, I think. Yeah,
Okay.
it's very interesting. It was, you'll not be embarrassed by looking at it.
Is that within the PICA boundaries?
It is. They didn't even ask for that, and which we could do that. But again, we were going to take that out of the PICA boundaries in the master plan, but we haven't yet. So never easy here, but we
Okay,
can have that discussion.
very interesting.
Yeah, it's pretty cool. So those
Yeah.
will be, for sure, that one's on your June 1st meeting, and Dr. Tala's on. And then I'll ask for us to set a public hearing for July for the facade renovation on Wilcox.
Now, how much time is Julie going to need to finish up her report here?
Yeah, that's, I want to make sure these are real dollars that we could be dealing with. So I don't know.
Okay.
I think these should go first, though.
I don't think we want to be there till 11, 12 o'clock either.
I agree.
Okay. Folks, you agree with that?
Yeah.
Yeah, I thought so. I thought so. Okay, anything else, Nick? Thank you. That's a very interesting report.
Nope, we're all set. Thank you, sir.
Any public comment come in, Siona?
No, if somebody's on the line, but I'm not 100% sure that they have a question, they didn't raise their hand, so I'm going to assume they do not.
Okay, very good. Thank you. All right, commissioners, any other matters or items for the commission? Unless anyone objects, this meeting is adjourned.
Thank you, everybody.
Very much.
Thanks, everyone.
Thank you.
Thank you.
Good night.
Thank you, everyone.
Thank you.